Well, hello, it's Tuesday afternoon at 4 o'clock. It was the start of our Zoom meeting. A couple of things I want to let you know. We are starting Unit 3. The first chapter is Chapter 21, which we'll discuss after I mention a few other things. It's important to think now to start thinking about the term project. What I mean by that is that you need to go to course content and look for the title term project and review the information and the outline. It's important you start doing that because that's due on 3/30. It's only about a month away. I just wanted to let you know ahead of time. You'll get other reminders about this along the way, but now's probably a good time for you to take a look at it and make sure it makes sense to you. And if not, you can email me and we can discuss it maybe at the next Zoom meeting. This is an interesting topic. This is a lot like insurance. Some things you just don't want to talk about and plan for. But remember, when we plan things, including exit strategies, it may be important for you to know and understand the inner workings of bankruptcy. The reason being is that you don't want to overspend or do something you don't need to do if you consider bankruptcy at a later point in time as an exit strategy. So it's just important to know, just like the ins and outs of insurance, it's important to know the players, know what you need to do in case that situation arises. Now, what happens is sometimes along the way, due to various reasons, you can end up becoming insolvent. And that is when the individual or business liabilities exceed their assets. This can occur for a number of reasons: economic downturn, mismanagement of financial assets, poor investment decisions, etc., some which you may not have control over. The debtor is the individual or business that owes the money. The creditor is the individual or business to whom the money is owed. Unless the problem creating insolvency can be quickly corrected, insolvency also leads to default. And default occurs when the debtor fails to meet one or more of the financial obligations to creditors. Then you turn to bankruptcy. It's a legal state that occurs when a debtor is insolvent, in default, or unable to fulfill obligations to pay creditors. In bankruptcy, the debtor's assets are sold to pay back the creditors. Making bad faith bankruptcy filings or to conceal assets or falsify records is illegal when you start getting involved with bankruptcy. The laws of bankruptcy filings are governed by Congress under Constitution Article 1. Congress passed the most recent amendments to these bankruptcy codes in 1978. Bankruptcy law is governed together both federal and state laws, which vary greatly, but under jurisdictions of the bankruptcy courts. Debtors and creditors should be aware of certain provisions that interact the laws both from the federal and the state level. Bankruptcy filings may be either voluntary or involuntary. Voluntary filing occurs when the debtor decides, I want to file for bankruptcy. Involuntary filing occurs when creditors petition the court to force a bankruptcy. And bankruptcy cases are administered by United States bankruptcy courts. Bankruptcy law is divided into chapters. In the federal bankruptcy code, there are chapters that govern each type of bankruptcy. Bankruptcy is found in Title 11 of the U.S. Code of Laws. For example, Chapter 7 of the federal bankruptcy laws. Security interest is created by execution of a contract between a debtor and a creditor. Perfection of security interest is used to determine the priority of claims among competing creditors. Under UCC Article 9, 3 ways can be done: who controls the goods, through automatic perfection through purchasing money security interest, or merchant office financing, or filing with a financial statement with county or state authority. Chapter 7, which is called total liquidation, is the most common bankruptcy filed by individuals and businesses. When petition for a Chapter 7 is filed, a trustee experienced in bankruptcy is appointed by the bankruptcy court. All collection of debts and lawsuits against the debtor are stopped. Assets of debtors are sold. This process is called liquidation, in which cash is obtained to use to repay creditors and attorney fees. Chapter 7 bankruptcy is sometimes referred to as straight or liquidation bankruptcy. Trustees divide assets into exempt and non-exempt categories. Exempt property up to certain dollar limits is protected from liquidation. Non-exempt property is not protected and liquidated. For example, it's some exempt property: pensions, limited equity in a residence, vehicles, appliances, pets, etc. Trustee collects the debtor's non-exempt property, sells it, and dispenses the proceeds in priority set by law and approved by the bankruptcy judge. It is the trustee's duty to distinguish between debts that are secured versus unsecured. A secured debt are loans to which specific asset is used as collateral or pledge for interest mortgages or loans for vehicles. 2 actions prohibited by a debtor under bankruptcy law are preferential treatment. No debtor gives favorable treatment to one creditor over another one. Fraudulent transfer. A debtor sells property from out far below market value, thus depriving creditors of fair value property being liquidated. May also include assets transferred within a certain time prior to bankruptcy. So be aware that if you transfer assets prior to bankruptcy, ensure that they're done well ahead of time. Discharge. At the conclusion of the liquidation process, most or all of the debtor's debts are expunged and do not survive bankruptcy. Examples of debts that are discharged are credit bills, credit card bills, medical bills, and lawsuit judgments. Bankruptcy law provides some debts survive the bankruptcy, including most student loans, alimony, child support, and debts that are re-signed during the bankruptcy process. Here's an example. Andrew ran up credit card debt and owed significant student loans. When she lost her job, she filed for Chapter 7. Andrew's credit cards were discharged, but the student loans survived bankruptcy and must be paid. The Bankruptcy Abuse Prevention and Consumer Protection Act of 2005 is a federal law setting strict rules and eligibility requirements for debtors filing for bankruptcy. Two important provisions. Application uses a means test and a requirement for a debtor education and credit counseling. The means test. This law provides debtors filing for bankruptcy under chapter must meet a means test. The means test uses a complex formula measuring an individual's income relative to the median income of persons in the state where they reside. Means demonstrated to bankruptcy court whether an individual is qualified to file for Chapter 7. If an individual's disposable income is too high, they not be able to qualify for file Chapter 7. In such cases, the debtor may be required to file under a different chapter of the bankruptcy law. The BAP-CPA law requires that debtors file under any chapter of bankruptcy law unless exempt. Must receive individual or group credit counseling from an approved not-for-profit individual or group budget or credit counseling agency. The debtor must obtain a certificate from the credit counseling agency, noting assistance in budgeting the debtors received. Counseling must be performed in person, by telephone, or online within 100 days prior to bankruptcy filing. That's very important. You may have to delay your bankruptcy or may not be allowed. Chapter 13 is an individual chapter for bankruptcy. In Chapter 13, debtors retain their property but agree to pay back all or portion of their debts as approved by the bankruptcy court. Debt payback occurs on an interest-free basis over a period spanning from 3 to 5 years. This is sometimes called a reorganization bankruptcy. Chapter 13 is initiated voluntarily, unlike Chapter 7, which may be initiated voluntarily or involuntarily. Chapter 13 eligibility, a debtor must show one, that the debtor has sufficient income to pay debts within a prescribed period, that the amount of debt owed does not exceed over $1 million for secured debts and over $336,000 for unsecured debts. In Chapter 13, certain debts are considered priority debts. Priority debts are debts sufficiently important they must be paid in full. Example of priority debts: certain tax obligations, alimony, child support, student loans, and wages owed to employees. Chapter 13 plan, when completed and approved by bankruptcy court, then all remaining debts are discharged and expunged. Debtors must first demonstrate that the debtor is current on alimony and child support obligations, that the debtor has completed that second budget counseling course with the agency approved by the bankruptcy trustee. Chapter 9 is a municipal one. Chapter 9 covers bankruptcy of a municipality. States may not file for bankruptcy. Chapter 9 provides a municipality with debt reorganization and repayment plan. While it does not liquidate municipal assets, municipalities do have the opposite option to do so. Bankruptcy court defines a municipality as a political subdivision, agency, or local instrument of the state. For instance, cities, towns, villages, counties, tax districts, power companies, and school districts. Chapter 11 is a business chapter 11 for partnerships, sole proprietorships, and individuals may file. But but Chapter 11 is mostly used by corporations, known as debtor in possession bankruptcy. Chapter 11, debtor proposes a reorganization plan to pay back creditors over time. Daily business decisions continue to be made and run by the existing management, but major decisions must be approved by the bankruptcy court. Chapter 12, bankruptcy, governs debts of family farmers or fishermen who earn an annual income. Chapter 12 plan is created to ensure that the debtor repays debts over a period from 3 to 5 years. Family farmer or fisherman may be an individual, corporation, or partnership. To be eligible for Chapter 12 bankruptcy, the dollar amount and percentage of the total debt are subject to limits described by the bankruptcy code. The Chapter 50 bank involves ancillary and other cross-border cases. This is a different chapter. This framework is provided for bankruptcy cases involving foreign countries. It promotes cooperation between the U.S. courts and the courts of other nations in bankruptcy via a process where foreign companies may obtain jurisdiction over U.S. cases and access to legal documents. Now, although most of these won't be pertaining to you, in certain situations, other chapters covering specialized bankruptcy situations defined by Congress. Now, in our world, we're probably only involved with Chapter 7 and Chapter 11. It's important for you to understand and read this stuff because down the road, it's not something you learn along the way. You should be able to do some work and understand the ins and outs of this so you are not confused and you can plan accordingly if, in fact, the decision is made for your exit plan to file for bankruptcy, which is okay because we as individuals, we take a risk on a business, and sometimes that risk fails, and this allows us and affords us the opportunity to go to bankruptcy and allow us not to lose all of our assets at the time the bankruptcy is completed. So listen, enjoy your week. We'll have another one next week. We're in Unit 3, and before you know it, we'll be in Unit 4. If you get that chance, please look at the term project. Take a look at it. You don't want to be caught off guard and do this at very late in the game. It's just so you can make sure you can do a good job and get a good grade. Well, this is it for now, and I look forward to seeing you or talking to you next week. Goodbye.